Hi and welcome to another Whitehead Moncton podcast. My name's Sam Corse. I'm a lawyer in the Contentious Trust and Probate team here at Whitehead Moncton, and I'm sat with Fariha.
I am Fariha and I am one of the dispute resolution solicitors here at Whitehead Moncton.
Me and Fariha work alongside each other in the Contentious Trust and Probate team, and we've just compiled a couple of case studies here because we found from previous podcasts that's helped just to run through and relate it to specific cases. I think Fariha is going to go through one first, and I'll be answering the questions, and then we'll go with the other case study, and Fariha will answer those questions.
So this is one of your cases that you've dealt with previously, Sam. For obvious reasons, we have changed the names, so we're not mentioning the names of the actual people involved in the matter. This is relating to a disputing will. Mary, who was the deceased, died in April last year at the age of 79. She left behind 3 children, Rachel, James and Alex. Mary's husband, who was also the father of her children, died in 2001.
Yep.
Mary was diagnosed with dementia in 2015. She left behind a estate worth of £500,000, and this was consisting of her property and several other bank accounts, etc. Mary had a partner, Graham, who she met in 2009. Graham is younger than Mary and aged 66 at the time of Mary's death. He moved with Mary in 2013. Mary's will was made 2 years before she died through a firm of solicitors. Under the will, she appointed Graham as the sole executor and leaves the entire estate to Graham. Rachel, James and Alex are concerned with the events regarding the will. They had never seen an eye-to-eye with Graham and do not believe that their mother had ever wanted to leave everything, including the property, to him. They believe that despite being diagnosed with dementia in 2015, she had been showing signs of poor mental capacity several years prior to her diagnosis with dementia. So I have a few questions for you now, Sam. What is the initial advice you would give to Mary's children?
Thanks, Fariha. So generally, I just tend to sort of set out the general requirements for a valid will and just sort of rule out where as much as we can. So the requirements for a will, you have the formalities of signing. It has to be signed in accordance with Section 9 of the Wills Act, which means it must be in writing and signed by the person making the will, etc., etc. And the signature needs to be acknowledged in the presence of 2 or more witnesses at the same time, and then they must sign and attest or acknowledge their signature in the presence of a person making the will. Usually where you have these wills where it's been professionally made, usually there's not too much of a concern. And as part of the other investigations, usually if there's anything that comes to light or concerns about that area, that usually comes up in the first steps that you take. So here I'd be more concerned with testamentary capacity, which is a requirement for a will, and that's laid down by case law. It's the case of Banks v. Goodfellow, and that requires a person to understand the nature of making a will, understand the extent of their estate that they're disposing of under the will, appreciate claims from people under the will. So in this case, appreciate that in that will, if she's omitting her children, that ultimately the potential claims that they could have on her estate, and then the fourth strand is that she's not suffering from any delusion of any kind, which would affect what she's doing under that will, so who she's choosing to benefit under her will. So I'd be advising firstly that given the diagnosis of dementia, sort of the concerns there, that the will was made 5 years after that, and there's quite a bit of an age difference here between Graham and Mary, which may give rise to some concern. And in this one, there was some concerns from the children that Mary never actually wanted Graham to move into the property, and there was a bit of concern that although the diagnosis was in 2015, she wasn't too great prior to that. So I'd certainly be concerned about the validity of the will, and look into the validity of it for that reason. What follows from that is sort of knowledge and approval as well. So a person must know and approve the contents of the will. It must not have been made under undue influence. Undue influence is quite a high threshold in terms of trying to prove. So, as I said, the investigations that you sort of undertake sort of cover all bases initially to an extent, and things sort of tend to come to light a bit later on, unless, of course, the children are aware of glaring issues of undue influence that need to be investigated further. But that's the initial advice I'd give.
Thank you, Sam. So the children believe that their mother may have made an earlier will soon after meeting Graham, but they are not sure of the content of that will. What advice would you give them there?
One of the key issues with bringing any claim against the validity of a will is you need to ensure that you benefit in the event that that will is proven to be invalid. Because of course, if a will is disproved for lack of testamentary capacity, then it follows that the person, of course, didn't have capacity to make that new will, and through doing so, revoke any previous will. So it's important to investigate the previous wills to ensure that you are a beneficiary or would benefit under the provisions of intestacy, which would apply if a person dies without a will, to ensure that there's of course merit in disproving the validity of a will. So I would just be slightly concerned to make sure and satisfy ourselves here that try and find that earlier will, because if it was made shortly after meeting Graham, it may include him again, and in which case, if it does benefit him as early on as that, then we're sort of especially on the disputing the validity of the will claim, we're up a bit of a uphill struggle. But it might not. It may just reflect that she wanted to protect the provision left for her children. But ultimately, they need to satisfy themselves that under any previous wills, they would be beneficiaries. Otherwise, they've also got to disprove the validity of that will. If that prior will made as far back as then also benefited Graham, and if there wasn't a will, then they would benefit under intestacy, because they're the children of Mary, and Mary wasn't married to Graham, and so Graham, cohabitants or partners, they're not a class of beneficiary under intestacy, and so that would be their motive. But they need to satisfy themselves and undertake some initial steps just to try and locate any previous will, or if they're satisfied that there isn't a previous will, that they would then benefit under intestacy. But it's important to just flag up that she was married before to John, and it would just be worth checking what John's prior will may have said if he had one, and that may point in the direction of any previous wills for Mary.
Thank you. What are the initial steps you would be advising the children to take?
Off the back of that, what I've just said, certainly be just approaching any firm of solicitors that may hold a previous will, just to make inquiries, certainly, especially if they need to investigate whether this firm of solicitors have made any previous wills. And also you can undertake a more generic search. There was a third-party provider who can undertake a search of firms in specific areas to see if they hold a will, and certainly undertake those steps. That sort of request can, to ramp it up a bit, because of course, these things can take considerable time. You'd also want to start undertaking some investigations more and ramp things up a bit more. So if there's concern about the validity of the will, I'd be strongly advising them to enter a caveat in against the Mary's estate, which would block an application for a grant of probate against this will. So if Graham applied to prove this will in order to get a grant of probate, which is required to sell property and close bank accounts over a certain value, that is blocked. And by getting that caveat in and blocking a grant being issued, it gives very good leverage in terms of being able to try and litigate matters, as opposed to a grant having been issued. And then it's not impossible, but things do become a bit harder if you've got a grant, because then you're up against it on potentially timescale wise, and you lose that leverage of the other person coming to the table in terms of settling if there's any concerns that need to be dealt with or ironed out early on. I'd also be advising that they make something called a Lark v Nugis request to the solicitors who prepared the will, just to the Lark v Nugis is guidance that was published by the Law Society to provide that a will draft, a professionally made will, they are under an obligation where there's concerns about the validity of a will to consider disclosing the will file to the person making the investigations. And within the will file will be attendance notes of the time, or there should be attendance notes of the meetings that took place and correspondence, and including emails and telephone calls with booking appointments, etc., just to see statements to that effect. The further, especially in the case of concern of testamentary capacity, also making an application for Mary's medical records just to examine these, because these will highlight concerns and any memory tests or anything that were undertaken medically, which would raise serious concern as to her testamentary capacity. And unless within the will file there may be a testamentary capacity that may have been carried out, which can be done at the time of making wills, and will practitioners regularly do. But if there's nothing within there, then usually you look through the medical records, and whilst it's very rare that any form of testamentary capacity would have been undertaken by anyone outside of drafting the will, it would certainly give strong medical evidence if there were concerns to potentially lead to a retrospective assessment being able to be undertaken to support claims of that kind. And then sort of the final one is statements from people who perhaps lived close by, neighbours who regularly saw Mary and saw any decline. If there were witnesses to the will who weren't, and this will was made during COVID, and in the actual case it was the will been prepared by professionals, but the people who witnessed it weren't, because of the circumstances at the time. It was actually two neighbours, and so certainly approaching them for comment on how Mary was at the time is certainly something I'd be advising that they do. So there's sort of other steps I may have missed, but they're the main ones to get it off and running and start compiling evidence before moving to writing a letter of claim and certainly pursuing it against Graham.
Thank you. Is there anything the children should be aware of in relation to the caveat process?
Yeah, so the caveat lasts for 6 months, and usually it should, where there's concerns and these are set out to perhaps a beneficiary who is under the will, so Graham in these circumstances, and he's made aware, he should be, if he's represented, he should be advised that he should sort of allow those investigations to be undertaken. But there are ways to be slightly aggressive, I suppose, where you can enter something known as a warning to that caveat, where the person who's entered the caveat needs to enter something known as an appearance as to ultimately their case and why the caveat should remain in place. And sometimes the caveat warnings to caveats do come in before you've undertaken any of those initial steps, and you have to make a decision as to whether you enter that appearance or not. Because if you enter that appearance, then it ultimately locks the caveat in place, and it then can't be removed unless it's agreed by the parties, or ultimately determined. The matter is determined by registrar, ultimately by a court. So you have to be aware of that could happen at any time, and that's just not it. When I say by a court, a probate action would need to follow from that if it's been locked. So. And that could be done by either party. So it could be done by Graham in this instance. He could initiate a probate claim off the back of that to prove the will, and it gets a bit complicated where it gets to this extent. But very quickly you could find yourselves in court proceedings and on hook in respect of costs. But that rarely happens, and usually you're given time to investigate matters, and you can extend a caveat for 6 months further. And again, if required, but as long as you keep the other side informed and updated as to what's happening, usually it's very rare that formal process comes into play. And then at the end of that investigation, you can ultimately take a view as to whether you commit to pursuing a claim or walking away and ultimately removing the caveat.